There are three types of marriages in Ghana under the Marriages Act, 1884 to 1985. A. Marriage under the Ordinance. Part 3. This type of marriage is monogamous. B. Mohammedan marriage. Part 2. This type of marriage is potentially polygynous. However, the man cannot marry more than 4 women. C. Customary law marriages. Part 1. This type of marriage is also potentially polygynous. Prior to the passage of this act, the 3 types of marriages were regulated by 3 different pieces of legislation. These were the Registration of Customary Law Marriages and Divorces Act 1985, PNDCL 112, the Marriage of Mohammedans, CAP 129, and the Marriage under the Ordinance, CAP 127. In practical terms, customary marriage and marriage under the Mohammedans Ordinance are polygamous, whilst Christian and other marriages are monogamous. The legal system permits the conversion of a potentially polygynous marriage into a monogamous one and vice versa. This is clear from the case of Attorney General of Ceylon v. Reed, Jurisdiction, A. District Court, Section 47, 1, F of the Courts Act, 1993, Act 459, provides that the District Court has jurisdiction in divorce or matrimonial causes or matters and actions for paternity and custody of children. Section 50 of the Courts Act, 1993, Act 459, also provides that a district court also has jurisdiction to hear and determine any action that arises under the Children's Act, Act 560, and shall act as the family tribunal and exercise the powers conferred on a family tribunal under the Act and any other enactment. B. Circuit Court. The jurisdiction of the Circuit Court in matrimonial causes is conferred by the Matrimonial Causes Act, 1971 and the Court Act, 1993, Act 459, MCA. Section 43 of the Matrimonial Causes Act, 1971, Act 367, confers jurisdiction on the Circuit Court to hear matrimonial matters because it defines court as used in the Act as the High Court or the Circuit Court. Accordingly, references in the Act to court include the Circuit Court. Section 41(1) of the MCA, for instance, states that the Act shall apply to all monogamous marriages. Section 41(2) further states that on application by a party to a marriage other than a monogamous marriage, the court shall apply the provisions of this Act to the marriage. The Act therefore confers jurisdiction on the Circuit Court to hear petitions for divorce, nullity proceedings, application for neglect to maintain spouse or child, and custody proceedings in respect of both monogamous and potentially polygynous marriages. Courts Act, Section 42, 1a of 4, provides that the Circuit Court has original jurisdiction in civil matters to appoint guardians of infants and to make orders for the custody of infants. Mensah v. Biko illustrates the jurisdiction of the Circuit Court in matrimonial causes. See High Court, Section 15, 1 of the Courts Act provides that the High Court has original jurisdiction in all matters in accordance with Section 140 of the 1992 Constitution. Section 18 of the Courts Act also grants the High Court jurisdiction in relation to infants. The High Court can therefore appoint guardians for an infant where the court is satisfied that the appointment is desirable having regard to the welfare of the child. Make orders concerning custody, the right of access, and period payments towards maintenance of the infant which are just in the circumstances having regard to the means of the persons concerned and the welfare of the infant. Remove a guardian and appoint a new guardian for good cause. Determine a dispute between a guardian and a parent. Intervene in guardianship where the court is satisfied that the guardian has acted or is likely to act prejudicially to the welfare of the infant. Make orders and give directions for the control and administration of the estate of the infant, including the investment of money where the court considers that it is in the best interest of the child. Make orders or give directions permitting the use of monies for the education of the infant, or for setting the infant up in an occupation or a career that the court considers desirable having regard to the welfare of the child. The MCA also confers jurisdiction on the High Court in matrimonial causes by virtue of Section 43 of the Act, which defines court to include the High Court. The High Court also has jurisdiction over appeals from the District Court. D. Court of Appeal. The Court of Appeal has appellate jurisdiction from decisions from the High Court and the Circuit Court. E. Supreme Court. the Supreme Court has appellate jurisdiction over appeals from the Court of Appeal. The nature of marriage. The concept of marriage contains both the ceremony by which two people become husband and wife as well as the status of being husband and wife. This is to say that marriage embodies both the contract of marriage and the status of marriage. The classic definition of marriage is given in the case of Hyde v. Hyde, where Lord Penzance defined marriage as the voluntary union for life of one man and one woman to the exclusion of all others. Four features of marriage can be gleaned from Lord Penzance's definition. Voluntary. A marriage can therefore be annulled if the consent of one of the spouses was not properly obtained. Indissolubility. This is not to say that there can be no divorce. However, it presupposes that unless proper grounds exist for the grant of a divorce or an annulment, the parties to the marriage intend to stay married for the rest of their lives. Heterosexuality. Monogamy. Marriage is a contract. Marriage is an agreement between a man and woman. It creates a legal relationship between them and imposes mutual obligations and rights on each party to the marriage. From this perspective, marriage is a contract between the parties. Just like any other contract, marriages may be void or voidable. However, the marriage contract is sui generis, and the grounds on which a marriage may be void or voidable are different from those of an ordinary contract. A contract of marriage can also not be discharged by agreement, frustration, or breach, as is the case with ordinary contracts. Apart from death, it can be terminated only by a formal legal act, pronounced by a court of competent jurisdiction. Marriage as creating status. Marriage creates a status, that is, the condition of belonging to a particular class of persons, married persons, to whom the law assigns certain peculiar capacities or incapacities. It is worth noting that whereas the parties to a commercial agreement may make such terms as they deem fit provided it does not offend statute or public policy, the rights and duties of spouses are fixed by law upon marriage. Despite this, spouses may free themselves of certain duties such as the duty to cohabit. However, there are certain duties and rights which cannot be relinquished by the parties upon agreement. An example is that neither party to the marriage may contract out of his or her power to apply to the court for financial relief in the event of divorce. Also, unlike a commercial contract, which does not affect the legal position of a person who is not a party to it, marriage may affect the rights and duties of third persons and the relation of the individual with government institutions. For instance, private or state pension may be payable to a person by virtue of their status as a surviving spouse. Breach of promise to marry. A marriage contract begins with the exchange of promises between a man and a woman. The contract may be express or implied. It is express when a proposal is made and accepted. It is implied where the agreement is inferred from the behavior of the parties towards each other or from the giving and acceptance of an engagement ring. There must, however, be evidence supporting a mutual exchange of promise to marry. The promise may be conditional, in which case there must be evidence of the fulfillment of the condition before an action can be maintained. Where there is a general promise of marriage, then an intention to perform within a reasonable time will be imputed. In Aining v. Kingful, the defendant promised to marry the plaintiff within 3 months after giving her a ring and a Bible. The plaintiff waited for 8 years, but the marriage never took place. The court held that a promise to marry is a promise to marry within a reasonable time. Therefore, if the promises are seriously made, a legally binding contract that can be sued upon is created. The consideration for the contract is the promises that have been exchanged. An action for breach of promise to marry therefore arises where a person who makes a promise of marriage to another refuses to marry that person. Types of breach of promise to marry. There are 2 different types of breaches of promise to marry. A. Non-performance when the time for performance arises. B. Anticipatory breach before the time for performance arises. Non-performance. Party A and Party B may agree to marry at a certain time in the future or upon the occurrence of a certain event. If Party A refuses to marry Party B when the time came or when the event occurred, Party A would have breached the promise to Party B by virtue of the non-performance of the marriage. If the promise is subject to a condition, express or implied, or is not to be performed until some time in the future, there can be no breach until the condition has been satisfied or the time for performance has arrived. Anticipatory breach. This occurs when before the contractual date for performance has arrived or before the set time, the defendant repudiates his contractual obligation and makes it clear that he has no intention of performing the marriage when the time arrives. It is anticipatory because the party in breach has put it out of his/her power to carry on with her/her part of the agreement. E.g., by marrying another person when he promised monogamous marriage to someone else. The repudiation gives the plaintiff an immediate right of action and he need not wait for the time of performance before he sues. A clear illustration of anticipatory breach is seen in Frost v. Knight. In this case, the defendant promised to marry the plaintiff after his father died. He repudiated the contract during his father's lifetime and the plaintiff sued for damages immediately. It was held that the plaintiff could recover notwithstanding that the defendant might die before his father. Defenses to breach of promise to marry, fraudulent misrepresentation, example. The fact that the person with whom the marriage was contracted had another spouse and that fact was hidden from the defendant. It is a good defense to an action for breach of promise of marriage that the defendant was induced to make the promise, or to continue the engagement, by misrepresentation or willful suppression by the plaintiff of the circumstances of his/her family and previous life. Bad character, S.C. Schnarr v. Jansen. The defendant alleged that the plaintiff had unpleasant relations, a murderer for an uncle, a thief for a brother. Barrett v. Vandermeulen. Infidelity on the part of the woman. When the plaintiff is a woman, the fact of her having been unchaste, whether before or after the making of the contract, constitutes a good defense, provided in the case of previous unchastity, the defendant was not aware of it at the time of his promise. C. Bench v. Merrick. Lewis v. Tapman. The defendant alleged that the plaintiff's mother was a prostitute. Infidelity on the part of the man. This could be a defense if the agreement is in respect of a monogamous marriage. Under Ghanaian law, infidelity on the part of the man will not be a defense if the promise was in respect of a customary law marriage. This is because customary law marriages are potentially polygamous. Insanity. Insanity may be a defense where the party relying on it can prove that the insanity rendered him or incapable of performing his or her part of the contract. A defendant can also rely on the plaintiff's insanity if it has rendered the plaintiff incapable of performing his or her marital duties. Unless it has rendered either party incapable of performing their marital duties, it is no defense to plead insanity simpliciter as a defense. Bodily infirmity. This will be a good defense where it is proven that the infirmity has rendered the defendant absolutely incapable of performing his marital obligations. The defendant may also rely on the infirmity of the plaintiff where it is shown that the infirmity has rendered the plaintiff absolutely incapable of performing his duties under the contract. Mutual release. It is a good defense that the parties agreed to withdraw and release each other from the promise and one of them cannot subsequently bring an action to claim damages. The defendant can rely on the fact that they released each other from the promise as a defense. Breach of promise to marry under customary law. Breach of promise to marry is actionable under customary law. Customary marriage is a union between a man's family and a woman's family. Essentially, it is also a contract between the man and the woman. Sarbaugh was of the view that there can be no cause of action. He states that he who desires a woman, whether maiden or widow in marriage, must apply to her family, or person or persons, in loco parentis for consent and without such application and consent, there can be no betrothal. Nor is there any remedy for breach of promise of marriage. If a man fails to marry a woman for whose hand he has applied, or if such a woman refuses to marry him, or her family withdraw their consent, no such action arises, and no damages are incurred by the person in default, who, however, forfeits any consignment or anything given to the other. The older authority of Sarbaugh is however challenged by the relatively recent publication of Professor Allott in 1960 in which he highlighted some cases where damages had been awarded by the native courts. He states that breach of a bare promise to marry which has not led to the establishment of the betrothal status often involves no legal liability to compensate. Ghana customary laws conform to the general pattern in this respect. Action for breach of promise of marriage are found in the native court records. In one such case, the claim was for compensation for special expense incurred as a result of the promise. In another case, the plaintiff as a man who had been disappointed by his future bride. Native court held that there was insufficient evidence of promise to marry. Donkor v. Ankara, 2003-2005, Korfer v. Sosu, 1979, High Court. Facts: the plaintiff, wishing to marry a certain woman according to customary law, approached her father, who informed him that his daughter was already married. A relationship nevertheless developed between the plaintiff and the woman, but the woman never went to live with the plaintiff as his wife. The plaintiff therefore sued the father and daughter jointly and severally for damages for breach of promise to marry. Held, a. It is trite law that marriage can only be contracted between two parties, each of whom has capacity to contract that marriage. Whether a person has capacity to contract a marriage is a matter of law. Referring to Sarbanes-Oxley customary laws, the woman whose hand is sought in marriage must be either a maiden or a widow. A woman who is already married and therefore not divorced lacks capacity to contract another marriage. b. The evidence showed clearly that the plaintiff knew or ought reasonably to have known that the second defendant was at all material times a married woman and lacked capacity to contract another marriage while her first marriage remained undissolved. c. On the evidence, the plaintiff himself sent messengers only to the second defendant, whereas at customary law the consent to the marriage must be sought by the man's family from the woman's family. It was arguable whether an action for breach of marriage lay at customary law. Kwame Addo v. Ajoaduko, 1915, Court of the Omanhene of Akima Bwakwa, Nana Surofori Ada, the male plaintiff and the female defendant orally agreed to marry each other. The plaintiff presented a necklace to the defendant in the expectation that the customary marriage would take place. The defendant failed to honor her part of the contract and the plaintiff sued her for damages for breach of promise of marriage. The court judgment for the plaintiff in terms of his claim and ordered the return of the necklace to him. Afrifa v. Class Peter, 1975, Court of Appeal. Afrifa met Class Peter and eventually proposed marriage to her. They became formally engaged with the consent of Class Peter's family, to whom Afrifa presented gifts of money, drinks, a ring, and a Bible. The nature of the proposed marriage was to be Christian and monogamous. The parties set up home together and in anticipation of the marriage ceremony. Class Peter gave up her employment as a GA schoolmistress. Between 1969 and 1972, Afrifa fixed several dates for the wedding, but each was postponed at his instance. In the meantime, Afrifa freely consorted with other women and had a child with one of them. Class Peter became aware of Afrifa's infidelities and finally followed him to a rendezvous where she caught him in the arms of another woman. She accordingly left the joint home and sued for damages for breach of promise to marry and successfully obtained damages from the circuit court. Afrifa appealed, urging that he was already customarily married according to GA custom and was therefore not in breach. In the alternative, he argued that since Class Peter had not sued when the marriage was first postponed, she had waived any rights that the breach gave her, and further, by creating a scene when she discovered her fiancé with a girlfriend, she had induced the breach or had introduced the element of frustration. Held, a. The postponements of the marriage at Afrifa's behest implied a willingness to marry at a future date. If Afrifa was in fact already married to Class Peter, according to GA customary law, the logical conclusion to be drawn from the facts was that the postponements were in relation to marriage under the ordinance. b. In fact, the parties were not married according to custom. The gifts of a ring and a Bible were unknown in customary marriage and no marriage custom had been performed. Mere cohabitation was not conclusive of the fact of marriage. There were at least 6 forms of valid customary marriage among the Ashanti, and various forms of GA customary marriage also existed. A man seeking to marry a woman from a different ethnic group should ascertain the formalities requisite for validating his marriage. Afrifa failed to do this, and even by GA customary law, he was in breach of his obligation to marry. Referring to Sarbanes-Oxley customary laws and Allot's essays in African law, it was stated that it is arguable that breach of promise to marry is actionable under customary law. c. Class Peter had not waived her rights. The postponements occurred between 1969 and 1972, and the time lag did not suggest a waiver. After each postponement, there was a new reciprocal promise and class beater's willingness to marry on the day ultimately fixed and sufficient consideration to support a fresh or continuing promising by a. Jarbang v. Tago. Facts. The plaintiff had an amorous relationship with the defendant prior to his departure for the United Kingdom, resulting in the birth of a child. On his return, the plaintiff sued him for, inter alia, damages for breach of promise to marry her. The court found that there was no evidence that the defendant had made any promise to marry the plaintiff either under the marriage ordinance or customarily. There was, however, evidence that the defendant, whilst a student in the UK, had written to the plaintiff informing her that he had made up his mind to marry her. There was also a mere allegation that the defendant had at earlier paternity ceremony agreed, even though not present, to wed the plaintiff. Held. A. There was no evidence of a promise to marry the plaintiff under the marriage ordinance Cap 127. The mere statement that the defendant had agreed to wed the plaintiff did not constitute any binding contract to marry. The defendant himself was not present and nothing was presented to signify any such promise. At the initial stages of amorous relationships, the parties are so in love that utterances are made by one party to another to sustain the relationship. Such utterances are often more of fantasies than of reality. Even though the defendant had written to say that he had finally made up his mind to marry the plaintiff, there was no evidence that the alleged promise had received the approval of the family. There was therefore no binding promise by the defendant to marry the plaintiff customarily. B. Customary law required the consent of the two families concerned to any marital relationship between a man and a woman. When a man desired to marry a woman customarily, he applied to the woman's family through his own family for their consent, taking to them certain gifts which would vary according to his means. The family of the woman would give their consent by accepting the gifts. Where the consent of the woman's family would not be gained either because they improperly refused to give such consent or because they resided in such a distant place that it was impossible to obtain such consent. A man and woman who voluntarily agreed to live as man and wife for life could contract a valid marriage provided that such agreement was expressly made in the presence of credible and respectable witnesses or in the presence of the chief or headman of the place, followed by the man and woman living as husband and wife. Thapia, A. Akiampong, W. V. Akiampong, H. The customary law wife of the defendant brought an action for breach of promise on the part of her husband to marry her under the ordinance. Counsel raised a preliminary objection that a customary law wife did not have a right of action against a husband and that even if she did, she could not maintain such an action. Amisa J. held that the incidents of marriage under the ordinance are quite different from those under customary marriage. And if a woman has given consideration for the promise to transform the one under custom into the one under the ordinance, it would be harsh to stop her from recovering for breach. Achempong v. Achempong, 1967, GLR 34, Badu v. Bokai, 1975, 1 GLR 283, Amoa v. Bokai. The plaintiff filed a suit against the defendant claiming damages for, inter alia, breach of promise to marry. The defendant presented a bottle of schnapps and GHS 5.00 to the plaintiff as traditional knocking. The family of the plaintiff accepted the drinks and the money. The parties thereafter cohabited at Kasoa from 2005 to 2009. The defendant eventually failed to marry the plaintiff as promised. The trial high court made a finding of fact that the defendant had promised to marry the plaintiff when he caused his parents to present the money and drinks to the plaintiff's family. The court awarded GHS 1,000 as aggravated damages for deceit. The defendant appealed to the Court of Appeal, which held that it would be unconscionable to hold that breach of promise to marry exists in ordinance marriage but does not exist in customary marriage. The court further stated that marriage under the ordinance is not superior to customary marriage as both of them are recognizable by law. To say that a promise to marry under the ordinance is well-founded but cannot be founded in customary marriage is discriminatory, unconscionable, and contrary to justice and equity. Ama Serwa v. Gariba Hashimu and Isaka Hashimu. Facts. The plaintiff and the defendant were in an amorous relationship in Italy. The plaintiff claimed that while in Italy, she engaged in prostitution at the behest of the defendant and gave her earnings to the defendant. The plaintiff alleged that they hoped to get married and set up home in Ghana, and so she was introduced to the defendant's parents, and she also introduced the defendant to her family. In fact, she alleged she even began receiving tutoring from the defendant's mother towards her eventual conversion to Islam, as was required by Islamic law. The plaintiff returned to Ghana with the intention of staying for a short while but was unable to return to Italy as she had lost her travel documents. While here, she found that some of the vehicles she had shipped to Ghana to be kept by the first defendant for the couple could not be accounted for. Also, the plaintiff alleged that while in Ghana, the couple lived at Tuntra Hill, in rented accommodation, as one of the properties the couple were building in Ghana, the Medina House, was allegedly not yet ready for occupation. While there, she heard stories about how the defendant was carrying on with other women at the Medina House and insisted on moving there. She, however, had to leave the house after a short period as a result of harassment she claims to have suffered at the hands of the defendant and his sisters. The plaintiff also she delivered a stillborn baby fathered by the defendant at the 37 military hospital. Within this time period, the relationship broke down. The plaintiff suffered a mental breakdown and had to be taken to Kumasi for treatment. Upon her return to Accra, she discovered that the defendant had married someone else. The plaintiff sued the defendant for breach of promise to marry, among other claims. The defendant, however, denied having any amorous links with the plaintiff, contending that she was already married with children so he could not have been in any relationship with her, held, referring to Professor W. C. Akau Daniels, in his The Law of Family Relations in Ghana as well as the case of Donkor v. Ankara. The court noted that it is now beyond question that actions for breach of promise to marriage under customary law are maintainable. In this case, the plaintiff and the defendant had been in a relationship. A knocking ceremony had been performed before the relationship broke down. A baby was subsequently born and named by the defendant. However, the defendant had by that time married somebody else. Where a man or woman makes a promise of marriage to another and fails to carry it through, it is a cognizable wrong for which the court would give a remedy. It is not the law that for an action for breach of promise to marry to succeed, there must be a subsisting customary marriage, whose failure to be converted to an ordinance marriage grounds the action, from the totality of the life they led in Ghana. The relationship between the plaintiff and defendant went beyond mere acquaintances in Italy. Therefore, the plaintiff's expectation of marriage had good basis. Having led her to believe that she was considered a wife, it was not unreasonable for her to seek compensation when she was chased out of the defendant's life empty-handed. Note that under Mohammedan law, unless the contract of marriage is completed, no rights and obligations arise, and therefore a suit for breach of promise to marry is strictly impossible. The only remedy that can be asked for if an engagement is broken is the return of ornaments, clothes, and money. Remedies for breach of promise to marry: the only remedy is damages. Specific performance will not be awarded by the courts because no one will be forced to enter into a marriage contract against his or her wishes. 3 categories of damages may be awarded: compensatory damages. Damages may be awarded for mental distress, damage to reputation, loss of economic advantage that marriage would have conferred, social disgrace, injured feelings, expenses incurred in preparation for the wedding, aggravated damages. Where there is evidence that the plaintiff was seduced as a result of the engagement, the plaintiff is entitled to aggravated damages. For instance, where the plaintiff is asked for sex in exchange for the promise of marriage. Non-disclosure of a venereal disease on the part of the defendant may also entitle the plaintiff to aggravated damages. Punitive damages. A court may also award punitive damages where the defendant has shown himself to be a thorough rascal, either through his motivation for the engagement or the manner in which it is broken. The usual grounds for awarding this type of damages are fraud and malice. See Finkelstein v. Barrett, Drobnich v. Bach. The quantum of damages is not fixed. A number of factors may be taken into consideration. In Donkor v. Ankara, the court stated that in respect of general damages, the plaintiff is entitled to some measure of this because from the evidence on record the relationship between the parties was so notorious within the small community in which they cohabited that everybody was bound to know it. This was likely to take the plaintiff off the marriage market and thereby affect her eligibility and suitability to get a partner. In this particular case, the plaintiff had a son for the defendant. This, according to the court, was additional baggage that the plaintiff must of necessity carry into any new relationship. This by itself was not an attraction to an eligible bachelor and may detract from the usual things that attract men to women. She may lose color, may not kick and glitter as she used to before the birth of his child, which is her second. What happens to gifts that are given by the parties to each other after the exchange of promises? This depends on whether the gift was given in contemplation of marriage or not. If one party gives the other a gift in the hope that they would be married in the future, the party receiving the gift must return it if he or she withdraws from the agreement as noted in Kwame Addo v. Adwo-Aduku. On the other hand, if the party giving the gift is the one in breach, he or she cannot claim it back unless he or she has good reasons for withdrawing from the contract. A gift must be given in contemplation of marriage, else it will be recoverable. Thus, gifts given such as Christmas presents or birthday presents, for example, may not be recoverable in the event of a breach. Whether a gift was given in contemplation of marriage or not is a question of fact for the court to decide. Is a gift recoverable after the marriage has taken place, as soon as the marriage takes place? The gift vests completely in the person who received it. It cannot be recovered even after a divorce. Thus, rings cannot be recovered after the marriage because each party fulfilled their part of the bargain in contemplation of which the ring was given. Where it is clear to the court that one of the parties entered into the marriage to keep a gift, the courts are likely to order a return of the gift if the party receiving it petitions for a default and fraud is established. Customary marriage. A customary law marriage has been defined in Yadi v. Key by Olanu J. as he then was as a union of a man's family and a woman's family. It imposes rights and duties upon the two families. The woman's family gains the right to perform certain rights in certain eventualities, and the man's family also gains the right to perform certain rights in certain eventualities. It is instructive to note that the involvement of the respective families arises from the day the family of the prospective husband asks for the hand of the prospective bride from her family. Customary marriages are also potentially polygamous as noted in Graham v. Graham. The forms and ceremonies necessary for the celebration of marriages are largely dependent on the customary practices in particular communities. The state is not directly involved in the important stages of the contract and celebration of the marriage, among which are the giving of notice of intention to marry, negotiations and presentation and acceptance of the marriage consideration. It is later that state officials are brought in at the state of registration of the marriage, which is of recent origin. Celebration. As stated earlier, the actual rights for the celebration of a customary law marriage differ from one ethnic group to the other, even though there are some common features running through them. In his book, Fanti Customary Laws, J.M. Sarbaugh describes the rights related to the celebration of marriage as follows. When a man desires to marry a woman, he goes personally and sends someone to her parents or family for her hand. If his proposal is agreeable to the family and he receives their consent, the consignment money or taken, valuing as much as he can afford, is sent to them. That is all that is necessary to constitute the marriage tie. Customary marriage among Ashantis. Customary law distinguishes various forms of marriage based on the status of the parties. The steps for a customary marriage among Akan groups could be summarized as follows. A man wishing to marry a girl sends some relatives to the girl's parents to ask for her hand in marriage. They go with a bottle of schnapps and some money for the knocking fee. This rite is known as a bisa. If they agree to the request, the messengers thank them with a bottle of schnapps. The Yus have a similar ceremony for Vafofo. Some people regard this ceremony as the engagement stage. It is also a period when both families conduct investigations into the background of the respective parties to the marriage. The next rite is the actual marriage ceremony, where the tea sika or head drink for the girl is paid and other presents are given, including a gift for the father, Agia Nabua, a gift for her mother, Aina Ni Tamboba. On this day, some refreshment is given to the visitors by the girl's relations. The Yus refer to this stage as the tababia. The next step is the nai. This means taking the girl to the man. Some presents are presented to the girl by the man's messengers. On the day, The bride's brothers demand compensation, which is called a kontasika, before they allow the messengers to take her away to complete the whole process. Rattray in his book Ashanti Law and Constitution recorded 6 forms of marriage in Ashanti. They are Adakai Awadi, marriage between a free man and woman; Afona Awadi, unions of a free man and woman under her husband's protection; Awawa Awadi, union of a husband and a wife who was also the husband or someone else's pawn at the time of marriage; Ae Awadi, substitution by the wife's family of another woman to take the place of a wife who has died; Kuna Awadi, marriage with a widow; Mpina Awadi, concubinage marriage. The payment and acceptance of Asida is all that is necessary to constitute a strictly legal marriage. In marriage ceremonies, the Asida may perhaps be loosely termed the bride price. Although this term may easily create a somewhat erroneous impression, for in no way is the wife purchased in the literal sense. Asida is paid by the father of the man to the father of the lady. Customary marriage among Fantas. This is similar to Ashanti customary marriages except Matsmana War, a form of marriage of free persons whose requirements have been copied from those performed in the case of a marriage under the ordinance, Esawa, child betrothal, Faya War, cross-cousin marriage. Marriage of mother's son to mother's brother's daughter. Customary marriages among Jia Dangmi. Among the Jia community, 3 forms of marriage may be noted: by cohabitation and repute, the voluntary consent of a man and woman to live together as husband and wife with the tacit approval of the woman's family and signified by the acceptance of a token. Boy Ekpa or Boy Ekpahomo or Sihamo, 6-cloth marriage involves the handing over by the man or his family to the girl's family of other presents for the girl or her parents; and Wayakwi marriage, marriage to appease the god/fetish. Customary marriages among the Dagabas, Sororit marriage, a marriage to a wife's sister or kinswoman; Leveritic marriage, marriage to a deceased brother's wife. No bride wealth is required to be paid. He must give 500 cowries to the woman's clan, and children born in the marriage belong to the deceased brother. Widow inheritance. This occurs when a man goes through a new marriage process instead of benefiting from the old one to get the widow. Preferential marriage, a type of marriage between people who have blood relationships, usually a form of cross-cousin marriage. Another variation is parallel cousin relationship, i.e., where a man marries the daughter of his father's brother or sister. Unlike marriages under Part 3 of the Marriages Act, CAP 127, customary law marriages are difficult to prove because of lack of documentation. Justice Alanu introduced the 4 essentials to correct injustices of the past and also to facilitate proof of the existence of a valid customary law marriage, especially in issues relating to succession. Before the introduction of the essentials, a valid marriage came into existence if drinks were presented by the man's family and accepted by the woman's family. If no drinks were presented and a woman lived with a man for a considerable length of time, bore children for him, and served him as a wife, those factors would not necessarily convert the relationship into a valid marriage. The woman would therefore not be entitled to benefit from the man's estate if he died intestate. Justice Alanu's view was that if there is evidence that a woman was acknowledged as a wife by the man's family, that acknowledgement alone would have created a valid marriage even if the man had not presented drinks to the woman's family, asking for the woman's hand in marriage. Likewise, if there is evidence that a man was acknowledged as a husband by the woman's family, that acknowledgement alone would have created a valid marriage even if the man had not presented drinks to the woman's family, asking for the woman's hand in marriage. Essentials of a valid customary marriage. The essentials of a valid customary marriage were laid down by Alanu J. in the 1961 case of Yaudi v. Key. In that case, the deceased lived openly with the defendant in Takoradi and in Accra. Upon his death, the defendant provided sponge, soap, perfume and other customary things for the bathing of the corpse and also held the feet of the corpse while it was being bathed. In compliance with the demand by Yaudi's family, the defendant performed all customary rites which a widow should perform for her deceased husband except the custom known as okula, which is confinement in a room for 3 days ending with bathing in the sea on the morning of the 3rd day. The defendant said it was against her religion. The defendant was provided with maintenance during the duration of the funeral and was given mourning cloth for the funeral by the family of the deceased. Later, the family of the deceased, in accordance with custom, gave the defendant in marriage to the paternal brother of the deceased. The brother gave the defendant's family drinks to signify his acceptance of the defendant as his wife. One of the issues that arose was whether there was a valid customary law marriage between the deceased and the defendant, since the deceased never formally asked for the hand of the defendant in marriage. Justice Alanu stated as follows: "The question whether the relationship between a man and a woman is one of marriage or concubinage is a question of law to be determined from the facts and circumstances of the relationship." That the defendant was a customary wife of the deceased because on the evidence all the necessary essentials were present. That a marriage under customary law is a lawful marriage recognized by the law.